So Mark is not able to be here today, which you can see, so I'll be taking it all. This past year, there haven't really been any major shifts in franchise law, but franchisors and franchisees, franchise businesses are following the major economic shifts that are hitting all businesses. We're seeing continued litigation on control issues, the issues of joint liability or vicarious liability and joint employers. And the biggest shakeup this past year has been the new administration and what their policies may be and what they've given some guidance that they will go into. That we look forward to seeing how that might shake things up in the next couple of years. All right, so first we look at the cases. And for this update each year, we look at the things that directly affect the Iowa practice. We look at Iowa courts, the 8th Circuit Court of Appeals, and the Supreme Court. And as usual, there's not a Supreme Court case. Every once in a while we get one. But we do have some 8th Circuit Court of Appeals cases. The first one we're going to talk about is Neubauer versus FedEx. And that was breach of contract, fraud, the North Dakota franchise investment law, definition of a franchise, which is my focus, those last two. So on the facts of this case, FedEx contracted with people to have service, these primary service areas, and they would pick up and deliver packages for FedEx. And these contracts, the standard operating agreements, when you would assign them, you sell yours to somebody else, FedEx would then sign them for an entire new term. So if you had a term of 10 years and you sold yours after year 9, FedEx would take them and sign the assignee for another 10-year term. So in 2004, Neubauer was assigned a contract. He purchased it from a previous independent contractor. And over the next few years, he purchased 2 more. Now in 2011, FedEx transitioned from this model. So he'd been working under it for about 7 years altogether to a new one. And under that new agreement, the FedEx company would not sign the assignee for the entire new term, just the remainder of the previous term. So he originally did sign on to those agreements in 2011, but then when he went to sell, his agreements were worth less because it wasn't a new, X amount of years term, it was less. All right, so he alleged on the franchise issues that they offered and sold him an unregistered franchise in violation of the North Dakota franchise investment law. North Dakota's franchise law is pretty similar to most of them. So we have the 3 elements. We have a marketing plan, the right to engage in business offering, selling, or distributing goods or services under a marketing plan or system. We have the substantial association with the trademark, and then also a franchise fee. So Neubauer claimed that picking up and delivering packages using the FedEx trademark, in the FedEx truck, and getting paid for the exclusive areas qualified as a franchise. Now the court decided that he was an independent contractor, like his agreement said, and that since he received his payments not from the customers but from FedEx, he failed on that first element. So they upheld the dismissal of all the claims in that case. The next 8th Circuit case we have is Martinizing LLC versus BC Cleaners. Now this is a Lanham Act trademark infringement and violation of the Minnesota Deceptive Trade Practices Act case. And it's kind of unusual because the defendants never appeared. So the record is entirely from the plaintiffs. And I looked up the plaintiff, and it is a large, I think they have about 400 different locations of dry cleaning franchises all around the world. So in the district court, they granted them an injunction against BC Cleaners, concluding willful infringement, but they denied judgment against the 2 member managers for personal liability, and they denied monetary damages and attorney's fees. But this wasn't good enough for plaintiff, so they appealed to the 8th Circuit, and the defendant still didn't come. Okay, so the facts, all presented by plaintiffs. So Martinizing is a franchisor, and their franchisee was not BC Cleaners, but KM Cleaners. And they had 2 franchise agreements in Minnesota. And KM Cleaners entered into an asset purchase agreement with BC Cleaners in August of 2014. And during the pendency of that agreement, before ownership transferred, BC took over the operations. And now in January 2015, Martinizing sent a letter to BC, cease and desist all operations. That's not a lot of time between August and January, so Martinizing was on top of it there because nothing changed outwardly, and none of the customers could really tell that there was any difference because it was just being operated by a different LLC, the signs, everything was the same. BC at that point continued to use Martinizing's trade dress and marks. So when you're looking at a default judgment, the circuit said you take the facts as true, and you have to decide whether they support a legitimate cause of action. Now the plaintiff, they asked for the treble damages under the Lanham Act, an injunction enjoining the use of marks, not only against BC Cleaners, the LLC entity, but also against the personal owners, as well as interest, costs, attorney's fees, all of that. So as proof, the plaintiff submitted emails from BC Cleaners that they had received. The first one, it was in March of 2015, where BC said, we don't want to be a franchisee, and we're no longer operating the stores, and we're happy to comply with the cease and desist. And along with that, the previous email from Martinizing to BC where they asked them to sign a franchise agreement. And again, this is March of 2015, where just in January they were sent that original cease and desist. It's very quick moving. In June of 2015, there's another email exchange, and it said that BC responded to an email from Martinizing saying, we were never your franchisee, we operated the stores for K&M, and the asset purchase agreement fell through, we left the stores, basically leave us alone. So the plaintiff also submitted a copy of the asset purchase agreement between K&M Cleaners and BC Cleaners. And the asset purchase agreement did contemplate the transfer of the franchise agreement. It obligated K&M Cleaners to keep paying the franchise fees until the sale. And during all of this, Martinizing never terminated those agreements. They never said that K&M was in breach and sought those remedies. So the circuit court held that, first of all, the Lanham Act bars punitive remedies when injunction is sufficient to do equity. And the record here established that they went into an agreement to buy the store. All they did was operate the store, and when the deal fell through, they left. There's nothing on the record to say that K&M missed any payments to franchise fees or that there were any actual damages to Martinizing, their trade name, dress, any of that. So plaintiff failed to prove that their conduct made any sort of exceptional case which would entitle them to those damages that they were seeking. Now, this is the moral here is just really choose your battles. They're a big company. They obviously have lawyers on retainer or in-house, but they didn't lose anything except for the money they paid to go to court here. The next case is the Northern District of Iowa, and this isn't really so much of a case as a non-case. There were some federal claims and some state claims, and they went to the federal court, and the federal court knocked all the federal ones out. And so the supplemental jurisdiction on the Iowa case, they said, well, we can't look at that now. We're not far enough along to make any real reason for us to. It's just a little exciting because there's a potential for an Iowa ruling on Iowa franchise law coming up if they pursue this in state court, and there's just not a lot of case law, and so we're constantly looking at the law and interpreting it and having to say, well, this is what I think. So it'd be nice if we got some more there. All right. So we also like to analyze sort of claims and trends. And here's the pie chart of last year's cases since we were here last fall. And not surprisingly, there were the most cases in contracts and in statutory claims and in termination. You can see over the years, just by the numbers here, these are the top 7 sort of ones that we look at. Termination, statutory claims, and contract issues are often at the top. They are this year, with statutory claims leading the way. And every year it's sort of zigzaggy. We're waiting to see like some real good trends here. But we have contract issues might be on a general uptick, and again, you can see terminations way up there. So it's one of those things where you just need to remind your clients when they want to terminate that they have to have a good reason and follow the Iowa law as well as their own contract. Okay. So the federal agencies, like I said, the new administration is perhaps the most exciting thing as far as employment law and franchise law. And so in January of last year, we had some guidance on joint employment under the Fair Labor Standards Act. And it was a multi-factor test, heavily fact-dependent, and it focused on the economic realities of the situation. So is the employee economically dependent on the franchisor in a franchise context? And if so, maybe the franchisor is joint employer with the employer for terms of employment law, ACA, ICE, whatever. So this June, the DOL announced that the previous guidance is retracted. The previous guidance was on the expanded concepts of employment and joint employment, and then also another one on misclassifying employees as independent contractors, which has been very significant in the past few years in a variety of business contexts. They didn't provide, however, much guidance in what they were going. They didn't put new guidances out. They just retracted the old ones. And so we're waiting to see what might come from that. But they're definitely moving in a different direction. All right. The National Labor Relations Board, the last few years, it's focused on its joint employer standard on indirect control. So this is one situation where Red, Browning, Ferris, Company A, Company B. Company B might have a whole bunch of employees, but Company A really tells them what to do about, what to do day to day. And so that would be the indirect control that would perhaps get vicarious liability or subject them to bargaining rights. So the current administration gets to fill 2 seats on the board. It's a 5-member board. It's already made 1 nomination. The last I saw, that hadn't been confirmed yet. And so that's definitely going to change the makeup of the board. I don't have a clock there. But we don't really know how yet. We have our guesses. It is expected to walk back. So combined with the DOL, there should be some new things coming down. All right, last year we talked about the new FDA menu labeling rules. They were supposed to begin this May, enforcement, but they've actually pushed that back a year for further consideration of what opportunities there might be to reduce costs. I think they got a lot of pushback from large companies and franchises about the cost of implementation. So these rules apply to restaurants and retail food chains with over 20 locations. And franchise companies need to aggregate their franchise locations, even if they're independently owned, for that 20 count. And the rule requires that there will be clear and conspicuous statement of nutritional information, calorie count on most menu items. And of course, to get that, you're going to have to do testing, and you're going to have substantiation and documentation will be required. And that's really where the expense comes in. It's not the printing of the new menus, it's all the science behind it and the documentation that you're going to need. So there's pros and cons here. Franchisors, they like uniformity. So that can be a pro. We're not going to have them dealing with maybe as many state and local regulations. This is about as specific as a lot of those state ones that were starting to come up were, and so we can see a lot of opportunity for preemption there. The cons will be, of course, the additional costs, as well as it does limit flexibility. One of the things just in larger business trends we've seen is localized interest, trying to make maybe either franchise locations or different company-owned locations reflect the communities they're in. And if they have to have all this menu information for every menu item in every different place, they might limit that, which might have given some of the newer franchises a little bit of a leg up there. And then it also just adds another level of franchisor control. So we're worried about joint employers, we're worried about vicarious liability, and all of that ties back with control. And now we have the federal government telling us we need to put more controls in the systems. Another item on my radar this year is gift card laws. So in 2009, we have a federal gift card and bank card law, and that is administered by the FTC. And then there's also lots of state gift card laws. So the federal, of course, applies everywhere, but here we do see a lot of local, more restrictive laws, state laws. So we have about 39 different states which have some sort of laws on their books. Iowa's is not very restrictive. It just defines what a gift certificate is. It disallows fees absent a contract, and contains in its sheet, I can never say that, provision. But there are some out there, if your franchise is leaving the state. So 10 states allow gift cards to be redeemed for cash if the value dips below a specific threshold. And these thresholds range from about $1 to $10. And so you can see where if you have that much variance in the state laws, it can be tricky. We have 15 states to prohibit inactivity fees altogether, and 11 that generally prohibit expiration dates. So generally, in a franchise system, the franchisors administer the gift card program. They have policies and procedures in place that are passed down to their franchisees. And then the franchisee is the one that actually interacts with the customer. And so if the franchisor documents, say, only comply with federal law, then you might have some issues because you've got these state laws coming up. So it's an important practice point to remind your client, if they leave state, that they need to be aware of this and perhaps have their documents pass on that liability to the franchisees and that responsibility, or include it in their training program or do something to mitigate that. So that's one of those sophisticated versus unsophisticated franchisor things. The bigger your franchisor, the more sophisticated they are, the more they're going to be willing to come to you for things like this and realize that it might be an issue. Another one of those things is the registration. You get a lot of the newer franchisors. They don't realize once they leave Iowa, you tell them that they come up with their plans to leave Iowa, and you really do need to keep registration states in mind as you're developing your growth plan. So Iowa is surrounded by a couple of different registration states, and I'm in eastern Iowa, so we have a lot of people wanting to go to Illinois. And Illinois is one of the harder ones. They have higher fees, and they have their own law, which they examine very closely when you put any documents there. So a smaller franchise may want to consider moving to a state that has perhaps easier regulations to meet. So there's 14 registration states. There's 23 states with business opportunity laws. In those, you generally just have to fill out a small form and pay a fee, and then you're exempt from those. And there's 16 states like Iowa that have relationship laws.
What is a relationship law?
A relationship law, like Iowa, it's a law that's mostly focused on the relationship between a franchisor and a franchisee. Not so much just the registration is about the franchisor and the state administration or the state regulatory bodies. But a relationship law is about how the franchisor needs to treat the franchisee. And
what, it's a breach of contract or something?
It can be an addition. So my next slide here is about the Iowa franchise relationship law. And so in addition to the federal protections that the FTC has for franchisors and that you might have in your contract documents, Iowa also says you can't terminate for less than good cause. You have to renew unless there's a really good reason. And it voids waivers of Iowa law, limits your choice of forum so that you have to be subject to it. It really gives added protection generally to the franchisee, because the franchisor is the one making these documents. The franchisee has very limited ability to negotiate in many circumstances, and so these relationship laws help protect them. If I'm going over under time, let me know. So the one thing that we have found with the Iowa relationship law too is you have to be wary of arbitration provisions, because arbitration provisions can sort of snag you right out from underneath the protections of the Iowa law. So if you're having a client that's looking at a franchise agreement, thinking about buying in, you know they've got some Iowa protections, you know, check that and see if there's arbitration, because that might take them out of the Iowa protections. The Iowa law also creates a private civil action right, and so if you believe your franchisor is violating your rights, you can take them to court on the Iowa law as well as the contract provisions or anything else. And that's what I have. So, any questions?